Judicial review, prevention of misuse or abuse of judicial power, and provision of suitable remedies are the basic principle of administrative law. This justify as above. Let's justify as how various organs of the state are able to uphold these principles. This is called judicial review, prevention of misuse or abuse of administrative power, and provision of suitable remedies are basic principles of administrative law. You can consider justify as how various organs of the state are able to uphold these principles. Means we have to evaluate about various organs of the state. Means you have the three organs and that is how we have to talk. So the three organs, if you take this sixth question. Now, part 1. So, we should start with about administrative law. Right definition. This definition, right necessity. Necessity is that we say it should be something called discretion, to curtail discretion. Already we have told this part. This. Now let's see administrative law, safeguards. Part 2. Safeguards by three organs. So let's say that legislature. It exercises control. This executive. It also exercises control. Then judiciary through judicial review. This, basically these are expected to, let's say, ensure, let's say, this is how the legislature, you can find this key safeguard for delegated legislation. This you can consider. Executive by, let's say, enforcing discipline. It can take disciplinary action. This, the misuse of powers may result into, let's say, disciplinary action by the government. And judicial review, let's say, it can strike. Right, act of administration. Like say, recent ruling on enforcement directorate. This. So the three organs are expected to ensure that the administration is not able to misuse its discretion. We justify as how various organs have to be able to uphold these principles. This you can see this. So then justify, let's say, you have to talk about justify part. Justify. When we write the justify part, in that we can say that the first two organs basically. First two organs are not as successful. Let's say they are not as successful. Let's say because you know that how you have, let's say, huge misuse of delegated legislations, and you'll find that scrutiny, evaluation. Let's say the very few level of delegated legislations are scrutinized by committee on subordinate legislation, committee on assurance. Let's say the committee on let's say this committee on assurance, that it has also very less that aspect. You can see this, they themselves are arbitrary. You can see this. So in our country you can find how 46% MPs having criminal background. So that question, let's say, to some extent judiciary has been able, let's say, the judiciary through judicial review, you know that the judicial review PIL system, you can talk about judicial activism, you will find this. how through activism this, let's say, tries, let's say electoral bond, you can see this electoral bond judgment section 66A of Information Technology Act 2000, Puttaswamy case Aadhaar, this. So judiciary has been to some extent, let's say, able to strike and let's say protect the principles of natural justice, protect liberty of citizen, you can say. However, still you can say that even if three organs act and the judiciary has been very proactive, but still you know that administration, you'll find that administration threatens citizens' liberty, property. You can find this arbitrariness in administration and misuse of powers. You will find this. Still we find that they have not been fully successful. So they have not been fully successful, if you see that. So they have not been fully successful in limiting the power. You can see that how Supreme Court told that there should be stop on bulldozer. This, but still administration, in Uttar Pradesh, in Madhya Pradesh, in Gujarat, you'll find, especially you can, yes, the Uttar Pradesh, Gujarat, in Madhya Pradesh, how, let's say, administration found the order of Supreme Court, you will find this. This is, let's say, law, whatever the laws they are enforcing, they are laws related to administrative law, procedural law, and then let's say even if there is a judicial order but they are not able to act respect even, the rule of law is threatened, you know that. That's why once a Chief Justice went out saying that India has a rule by law, the rule, let's say that, rule by law, right, rather than rule of law, you find this the rule by law rather than rule of law. So this is what you can, that's why we need to have, let's say that safeguards, so part 4, safeguards. And safeguards would be minimal number of laws. Minimal number of law that can be considered. This pre-legislative scrutiny, that should be 2014 it was introduced, but we need to make it more. We'll find this. Then we can consider that political reforms to strengthen functioning of parliament. This more transparency, accountability. That is called actionable accountability. So there should be more and more, let's say citizens' participation, civic political culture. So if you want that administration should honor citizens' rights and protect citizens' liberty, we need to make the three organs more effective. At the same time, there should be more and more participation of citizens. The way Western countries can have civic culture, and civic culture reduces chances of arbitrary action by administration. That is how you have to write. So it is a bit applied nature of question, which demand your, let's say, application based content in terms of the three organs, not only one organ. And you have to, let's say, reduce again the focus. You can write in details, but that is how it should have been structured.